I'd like you to just talk to us about the legal tests that the courts will look at to actually say that for sure, this was constructive dismissal. I'll be happy if you give us examples from your practice, or even from other cases that others have handled.
Okay. First, address the tests. It's important that we look at the locus classicus, or the case that anchors constructive dismissal. And this case went all the way to the Court of Appeal. Now, the case is Coca-Cola versus Mary Kagay. And in this case, Mary Kagay was an employee of Coca-Cola and had risen through the ranks to the point where now she was in the executive position or managerial position. She was basically at the top of her career. And then little frustrations started coming in. The first frustration was that she would be moved from a particular station to a particular station. So it came to Nyeri, Uganda, when she moved to Kampala, then to Kisii, then to Kisumu, then back to Nairobi. She was
I think
moved
Mozambique
to 6,
too.
And to Mozambique. So she's moved to 6 stations in a period of 6 months. That's number one. And I want you to just think about the psyche of that, being moved from country to country, county to county in a period of 6 months. Then additionally to that, when she would go to those stations, there would be nothing for her to do. So she was actually left to be idle and seated on those particular spaces doing nothing. And then there was, over and above that, she was being excluded from meetings, yet she was actually in a managerial position. And when the court was looking at this, the court said that despite the fact that she resigned, because on paper, it does look like she resigned, the court has to go and lift the veil and actually look at the substance or the circumstances that led to Mary Kagay resigning from Coca-Cola. And the court went and said, when we look at these circumstances, then it is apparent that there are 2 ways to check whether there is constructive dismissal. The first test the court said is the contractual test. The contractual test is, are you changing the terms so fundamentally that it is actually in breach of that contract? Or is it, or in law, what we call repudiatory breach, which is you're fundamentally changing the terms so much so often, you know, being taken from one station to another, being made to be idle, yet you are hired contractually to do a particular task. So that is what the court looks at, the contractual test. And even if I expand that, if your salary is unilaterally reviewed downwards, if your contractual term, like you said, I was on pension, permanent and pension, I'm now being forced to get into a contractual term. The court looks at those issues and say, that under that contractual test, would an employee reasonably agree to continue working to that? Yet when they got into the organization, those are not the terms that they thought would be there. Or people are being given bonuses and you're not being given bonuses. So that's the contractual test. Are there changes to that contract? Secondly, the court then looks at the unreasonable test. That is to say, is the place that, or the environment has been made so toxic that it is no longer reasonable to expect an employee to continue working there. And reasonability is based on the reasonable man's test. That any man looking at this environment where you're being moved every month to a new station, you're being left to just stay there. Or in a different case of Rao versus Power, where an employee would actually just continuously be, you know, the boss was sending her messages that had sexual innuendo. And even when she raised it to HR, HR just did a sham of an investigation. And even when she was on leave, she was being called back to work, despite the fact that she has demonstrated and said that the CEO is actually sexually harassing me. So when she resigns, is it expected that she resigned because of her own volition, or did she resign because the environment was so toxic, so untenable, that it is no longer viable for this employee to work
continue
there?
working there?
So those are the 2 tests that the court looks at. But even as I close on those 2 tests, in the Mary Kagay case, the court stated that the issue with constructive dismissal is that it can be stretched. I can say they removed me from our WhatsApp group, so I've been constructively dismissed. I can say that that there was a meeting and I was not called upon, and maybe intentionally there wasn't. It was just an impromptu meeting, and I call it constructive dismissal. So the court said that it will look at, number 1, the context. it has to apply first an objective test. Because objectivity should be looked at against the feelings. So then it is not, I felt this way, that's why I resigned. It is objectively. Did you resign because you were not performing? Or did you resign because of the environment? Yes.
I like that. And maybe just to add a few things on the same. When it comes to constructive dismissal and like other times of separation, it is the employee who is resigning because they're saying it's almost like a forced resignation. It's like you're being, and I've also seen even people asking someone, please resign. And they're almost forced to resign. So it's a part of constructive dismissal. And when it comes to that matter going to court, now for this particular one, it is the duty of the employee, not the employer, to actually prove, it's a burden of proof is on the employee to prove for sure it was intolerable and they could not work because of the following. So for the employee, if you agree to actually stay in that environment for so long, you're almost accepting that maybe this has been discussed, you are agreeable, and therefore it will be a problem for you to even go to court after 2 years of having access. So because it is you saying you could not take it, if you have taken it for 3 years, then they'll come and work against you. So you have to understand when it comes to constructive dismissal, for the employee, it is very different. Including, are you actually escalating? Are you finding ways to solve this thing that is disturbing you before you even resign? What have you done to actually make your environment easy so that it can now meet the test that Stella is talking about? Did you try to even use your internal mechanisms, grievance procedure, for you to even qualify to call it constructive dismissal? Thank you very much. Tune in for more.